So, duty of confidentiality. This is one that, if you're in law school, this is one they like to test. There's an actual test about a lawyer's adherence to the model rules, their ethical responsibilities, called the MPRE, the Multi-State Professional Responsibility Exam. And they love to test confidentiality. Generally, whatever information a lawyer receives about a client during the course of representation, they should just keep quiet. That's the general rule. If you cared, the rule is called 1.6. But they're not supposed to be blabbing your business all around town, gossiping, things like that. So they have a duty to keep that information quiet. Now, if they hear it from some other source, it's in the newspaper, of course they can talk about it. But the idea is, why go blabbing about your client's business? Now, there's some exceptions to the duty of confidentiality. And if a lawyer is in a dispute with the client and the lawyer needs to give up some of this confidential information, like how many hours they work for them, because maybe they have a dispute over how much the lawyer is owed, they can give up enough of this information to protect the lawyer's rights. Or, and this has happened a number of times, if the client has used the lawyer's services to defraud someone and the lawyer was unaware of that, the lawyer can give up just enough confidential information to protect their own interests. There's a lot of other little exceptions too. And this is a pretty big one actually. If you as a lawyer know that your client is going to go kill someone or cause them serious harm, you may, it's not mandatory in the model rules, you may warn the persons if they can be identified and help to avoid that tragedy. Texas actually requires you to do that. California, I believe, still says you can't do that. So it's all around the map. It's a little bit different. But the general rule is you may go ahead and give up information like that. There's also a rule for financial dealings, too. If your client has been using your services to bilk someone out of money, you can go ahead and give them up as well to protect the financial interests of another, financial or property interests, like maybe they're taking money or even real property. Now, there's one other thing I like to talk about too. I'm not sure it's really in your book, but I'll talk about the 4 special cases in a moment. But there's also something, and a lot of people mistake these two things, confidentiality and attorney-client privilege. Attorney-client, and it's not just lay people, but lawyers mess this up all the time. Anything that's just deemed to be confidential, a lawyer shouldn't go blabbing it around. No gossiping, that kind of thing. However, if a lawyer was brought into court and put under oath, they would have to give that information up in a court of law if they were compelled by subpoena, let's say. But attorney-client privilege information is a special exception to the confidentiality rule that says you cannot be compelled by a court to give up this information. Attorney-client privilege is a tiny, tiny subset of all the information that you get from your client. It's only for information from the lawyer to the client or from the client to the lawyer for the specific purpose of getting legal advice. So if you and your client are talking about business advice, no legal issues at all, talking about your girlfriends, boyfriends, whatever, both, have at it, whatever you want. That would not be protected by the attorney-client privilege. Now, your book talks about 4 special cases, and I probably wouldn't have called them special cases. I just would have called them something else, but I'm trying to use the nomenclature that you're working with. So lawyers who represent corporations are actually representing this fiction. There is no physical being of a corporation. It is a legal fiction. It's not the building. It's not the shares of stock, if you could pile them together. There is no tangible corporation. It's that legal fiction I've mentioned now 3 times. So the problem is when you represent a corporation, you have to deal with some person, right? Somebody hired you. And that person is going to be very much convinced that you represent them. And so occasionally, an employee will be doing something that will be very harmful to your client, the corporation. You catch them doing something that they shouldn't be doing that's going to seriously harm the lawyer's client, then they have a duty to do certain things. To protect their client, they have to ask that person, first of all, desist, don't do this anymore. And they'll probably say, listen, you work for me. And you have to remind them that, no, I work for the corporation and I don't represent you. And if that person is really going to be in legal problems, have legal problems because of what they're doing, the only legal advice you should give, a lawyer should give them, is to get their own lawyer, because you do not represent them. Now, it is possible to represent a corporation and a person if their interests are aligned, but this is not what we're talking about here. So if they persist and they refuse to listen to you, you have a duty to go up the chain of command to their boss, all the way to the CEO or board of directors if you must, to try to protect your client. And what happens here is you're going to be fired, right? But you still have a duty to protect your client. And you don't have to, but you may actually even go outside of the corporate structure if you believe that there's some really bad thing going on. You can actually go to an appropriate agency. Let's say the firm is a corporation and they're issuing securities or stock or some bonds or whatever. You could actually go to the SEC if you believed you could help stave off harm to your client. Another special case here we see is best understood with an example according to your book. Oh, yes. So I already mentioned this, the fraudulent scheme they've used your services for. The next one they want to talk about is a lawyer is not permitted to offer evidence that the lawyer knows to be false. But maybe you learn about it after the fact. Well, if that information has been before the court, then you have special duties to take remedial measures, reasonable remedial measures. And it's very complicated, actually. It's a procedural nightmare. But the lawyer would have a duty to, not just to the client, because here it seems like it's really not about the client, but you have a duty to give up that information to the court that your client has actually perjured themselves. And then, is there another one? Yes. And then if you've, other measures before the tribunal, like if you learn that one of your clients has actually bribed jurors or something like that, as your book mentions, again, you must undertake reasonable remedial measures.